Appeal and for the 6th District of the State of Florida is now in session. Honorable Dan Traber, Chief Judge, presiding. All persons having business before the court call here give attention to the rules first. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning, everybody. Welcome to an oral argument session of the 6th District Court of Appeal. As Marshall Crawford indicated, I'm Dan Traber. I'll be presiding over today's sessions. We have 3 cases on the docket today. Before I get to those, let me introduce the rest of the panel. Seated to my right and your left is the Honorable John Stargel. And seated to my left, your right, is the Honorable Diego Madrigal. Judge Madrigal is an associate judge. His day job is at the Ninth Circuit Court in Orlando. The Chief Justice of the Supreme Court has recognized our workload and allowed us to bring in associate judges to help us do that. We're really grateful to have Judge Madrigal here with us today. This is being streamed live on YouTube, so if you haven't silenced your cell phones already, and that goes for the folks in the gallery too, we'd be really grateful if you did. The first case on today's docket is Jenna Brugal versus the City of Naples. It's case number 23-4088. Counsel, will you be arguing for Ms. Brugal?
Yes.
All right. How much time would you like for rebuttal?
5 minutes.
All right. That's the standard amount, so that's easy. Whenever you're ready now.
Morning, may it please the court. Hi. This case is a discrimination case. Ms. Brugal is a law enforcement officer who works for the City of Naples. This case came before this court on an order dismissing her complaint. Her complaint was filed under the Florida Civil Rights Act. Now, there are 2 issues that were raised on appeal. From our point of view, if the court decides the first issue, there's no need to address the second. So the first issue is whether or not in reviewing the motion to dismiss, the court went beyond the quote-unquote 4 corners rule. And in our determination, the court did. What happened procedurally is
The argument from your colleague is going to be that the court could do that, the trial court could do that because it related to subject matter jurisdiction. I'm generally curious about this concept of exhaustion of administrative remedies being a creature of subject matter jurisdiction versus what you might call procedural or case jurisdiction. You know, one's obviously waivable and the other one can be raised at any time. Would you address that particular dichotomy between subject matter jurisdiction and case jurisdiction in this setting?
Your Honor, I think in this context, it's an exhaustion issue. And part of the problem that we had in this case is that it involves a factual issue that should never have been addressed at the dismissal stage.
Yeah, but my question is that if it gets to subject matter jurisdiction, you can address it at the motion to dismiss stage. You know, some of the cases that are cited in the answer brief and below have to do with sovereign immunity, for example. And you can address that at the motion to dismiss stage, even by going outside the 4 corners of the pleadings. For example, you could address subject matter jurisdiction at the motion to dismiss stage if a plaintiff said that the amount in controversy was over the jurisdictional amount and the defendant said it was under. So you can do it at that particular point. You can go outside the 4 corners. I'm wondering about that, whether or not that was error to do that in this case.
Your Honor, it was error to do that in this case. And I cited a couple of cases like the Summerlin case that is directly on point, that basically talks about the way that the statute works. What they're addressing is actually a condition preceded. When we allege condition preceded in this case, and that's in terms of filing with the administrative agency, whether or not the charge was done the right way, the rule 1.120 basically says when it comes to conditions preceded, which is what is at issue, you just need to allege that generally.
Do you believe that Summerlin stands for the idea that exhaustion of administrative remedies is not subject matter jurisdiction?
I think it stands for the principle that unless it's apparent on the face of the complaint, like in some of the other cases. Like there are some cases where a plaintiff files a complaint and attaches a charge of discrimination or attaches documents that makes it akin to a subject matter jurisdiction issue.
Yeah, maybe I just asked that question the wrong way. Let me try again. So
Okay.
like with my example with amount in controversy. So say that you're a plaintiff and you say that the amount in controversy is higher than this particular amount. And obviously, you know, an employment discrimination or a PI case wouldn't be a great place to make that
Correct.
argument. A breach of contract case might be.
Correct.
And the defense says, no, I can show you that it's under the amount in controversy. In that particular scenario, aren't you automatically going outside the four corners of the complaint to
Not,
determine it?
not.
Or do I just have to take your word for it?
And for this kind of issue, you have to, but if it's akin to a conditions preceded, you have to. Let's say, for example, you're arguing that the amount of controversy is greater. One way that it can become an issue like that is if, for example, a contract is attached or a demand letter is attached, and the demand letter demanded $100,000, and then this court's jurisdiction is only 20,000 or 10,000, then I would agree with you in that respect. But I think someone instead.
But what if it's not attached? And then, go ahead.
No.
What if it's not attached? What if it's a situation where the plaintiff, and let's just ascribe nefarious reasons that have nothing to do with you or your client. Let's just say that the plaintiff knows that it's below the amount in controversy, and the way that they try to get around it is not to attach the contract at issue. Cannot at that point the defense attach an authenticated copy of the contract and say there's no subject matter jurisdiction here, Judge?
I think contract cases are different. So
Yeah.
that's the problem with.
This is all an analogy.
Yeah. If
Yeah.
this were a contract case and the plaintiff was suing on a contract, then maybe that could apply. But this is not a contract case. The plaintiff is not suing on the charge of discrimination, but instead on the statute itself.
Generally, would you agree that there's circumstances where you can go outside the four corners of the complaint to establish subject matter jurisdiction?
Let me give you an example.
Well, it's-
I agree. There's sometimes. And let me give you an example. There are some of the cases that are cited in the brief. There's one case, let's say, for example, there's a case in which the plaintiff attaches a copy of the charge of discrimination. And at that stage, if the charge of discrimination is attached, and then you can see a defect in the charge or some deficiency that the defendant can address, which would be akin to like a judgment on the pleading, then I would agree with you. But that's not what happened here. And then the other difficulty that was in this case is that which we objected to, is that even if you're going to plan to use a version of the charge, you need to make sure you use the right version. So that was another problem that we had below, because what the judge was presented with was a redacted version of the charge that removed some of the language that in our position contradicted some of the arguments on that the defendant was raising in terms of whether or not she properly filed the charge or not. And that's why that type of issue needs to be decided at the summary judgment stage and not at the dismissal stage. Okay.
You may keep going.
Okay, thank you. Okay, so if the court, as I said, if the court decides that that issue, and there are some cases that I've cited here that says if we get rid of that issue, then we don't even need to address the second issue.
So if I understand your response to Judge Madrigal, you're not arguing that there aren't certain instances when you can go outside the four corners if you're trying to figure out subject matter jurisdiction, but you're arguing in this particular case that this is inappropriate to do it because it's a condition precedent to suit and not something that gets to the court's ability to hear this category of cases.
Correct.
Okay.
The second issue, which is maybe the sexier issue, the more interesting issue, that is pending before the Florida Supreme Court right now, is the issue of whether or not, if we are allowed to go beyond the four corners and you want to address an issue in terms of whether or not, so now the court now has to look at the charge. If we ever get to that issue, you look at the
I want
charge.
to ask you about something in the statute. I want to ask your colleague about it as well. Doesn't seem like it's really called out in the briefing. I listened to the Supreme Court OA in Ramos. They didn't ask about it. So
Okay.
I'm hesitating to think that I'm special. But if I look at subsection 3, it says, except as provided in subsection 2, which doesn't relate to this case or Ramos or Bellany, the commission shall investigate the allegations in the complaint. How come we're not done here as a result of that?
Okay, good question. And that's because of the work sharing agreement. The way that the statutory scheme is
No,
made
I
up-
mean, how come, because of the work sharing agreement and because it's dual, it's not an aggressive question, it's a friendly question to you. So like because of the work sharing agreement, it's automatically dual file. That's
Correct.
not at issue in this particular case. Your colleague has graciously conceded that issue, both below and here. So it's filed with the commission, and it says, except in this particular situation, the commission shall investigate the allegations.
Correct. And it was investigated by the EEOC.
Well, and presumably the Florida
Correct.
Commission on
behalf.
Human Rights.
Correct.
Yeah.
Correct.
So I don't understand, based on that particular statutory subprovision, how you have a situation where just saying whether it's an EEOC employee or otherwise who helps a prospective plaintiff do this, I don't understand how just writing Title VII in there to the exclusion of something else, given that statutory language, wipes out that person's ability to sue under the Florida Civil Rights Act.
I agree with you. And your statement or what you just posed is consistent with the way that the legislature says and the Florida Supreme Court says we're supposed to interpret the statute. In my opinion, the statute is clear in terms of the scheme. It's clear in terms of what you need to, I think the question's coming, so let me stop. Okay. In terms of what you need to state in the charge, which Ms. Brugal did, the statute doesn't say you have to say, I am filing a charge with the
Well,
Florida Commission.
there's two sections of the statute which I think could be construed to hurt your client. You know, they're both from sub 1, and it says in lieu of filing the complaint with the commission, a complaint under this section may be filed with the EEOC. And then there's a second sentence later on that says the complaint shall contain a short and plain statement of the facts describing the violation and the relief sought. So take either of those two provisions at your leisure and tell me why it shouldn't benefit the employer in this particular case.
First, we have to start with the language of the statute. The language of the statute doesn't say you have to put any magic words. The second thing that we have to take a look at is what the courts have held in the past. The courts have held that this scheme is intended to be liberally construed. It needs to be construed in favor of access. Ms. Brugal did what she's supposed to do. She did a plain statement of the law, of her claim. She gave the employer notice of what the substance of her claims were. And there are some cases in which, let's say, for example, the courts have basically held that we're not going to use procedural
Can
technicalities.
you define substance of her claims for me?
Let me give you an example. Let's say, for
Well,
example,
I'm talking about this particular case.
in this, the substance of her claim would be, for example, I'm a law enforcement officer. I worked for the city of Naples for X number of time. While I was employed with the city of Naples, I was subjected to a hostile work environment, which included certain inappropriate comments. I was subjected to disparate treatment in terms of discipline and training. And after I complained about discrimination, I was subjected to retaliatory action. And that's the substance of her claim. And that's similar to what she asserted in the lawsuit: disparate treatment, sex discrimination, hostile environment, and retaliation.
Where in her charge is relief sought?
Um,
Because if I hear what you're saying is that the relief sought isn't the statutory scheme, you know, in terms of Title VII or in terms of the Florida Civil Rights Act. What you're saying relief sought is I want back pay, or I want the actual job that I was deprived of, or I want, where is that in the charge?
let me see if I have a copy.
Yeah.
She,
If you have it, go ahead. Otherwise, I was going to
okay,
suggest you
she,
address
for
it on
example,
rebuttal.
she talks about promotion. There's a line that says that she also believes that other women in the department are denied promotion and training because of their sex. Let me see.
I think Judge Traber is asking, where does it say, this is what I want? I want my back pay. I want a promotion. I want to be put back in the same position. Does it say that in the statement of claim?
I don't believe it says it like that, and most charges don't say it like that.
How are they supposed to know if it's under federal or state law or what exactly they're searching if it's not enumerated in the complaint?
And well, first, the charge of discrimination, at least the portions that were redacted from what was filed below, it says above that she wants to have this filed with the Florida Commission of Human Relations and the EEOC. It says she wants a dual file. There's a portion in the charge that talks about how she wants to preserve her rights under the EEOC statute to invoke the EEOC's jurisdiction and where dual filing or referral arrangements exist to begin the state or local proceeding.
Right. Then when it gets to the complaint, should there not be some more specificity?
I'm sorry,
Shouldn't there, in the complaint itself, as to what she's seeking?
Okay. When you said a complaint, do you mean the charge of discrimination or the complaint filed in court?
Complaint filed in court.
The complaint filed in court does have more specificity.
Okay.
We go into more facts, we go into the adjunctive relief, declaratory relief, and what else she wants.
You're into your rebuttal time. Do you
Oh,
want
I'm
to keep
sorry.
going? No, you can keep going if you like. It's your
No.
time.
I'll reserve unless you
Okay.
have any other questions. Thank you.
Good morning.
Morning.
John Keller on behalf of the city of Naples. May it please the court.
We obviously have questions for you.
I figured you might.
Would you address the subject matter jurisdiction versus the case jurisdiction question first? Because, and I'm not saying that you don't have sister DCA backup for it, most predominantly from the fourth, although there is some stuff second or third, not subject specific, but that notes the idea that exhaustion of administrative remedies can implicate subject matter jurisdiction. You have the first DCA that seems to indicate the contrary. There's a recent concurrence from the fifth DCA which indicates the contrary, which suggests that the exhaustion of remedies doctrine is made for judicial convenience, and it doesn't implicate subject matter jurisdiction. If that was a coherent question, could you address my concern?
I think I understand your question, Your Honor.
Perfect.
And let me start by addressing the cases that appellant cites in support of their argument that it was improper to go beyond the four corners. Respectfully, I think those cases are inapposite, and the reason is they don't analyze the question of subject matter jurisdiction. Summerlin, for example, the argument was that pursuant to Rule of Civil Procedure 1.130, the charge of discrimination needed to be attached to the complaint. Well, as we all probably know in this room, that is typically a rule that's used for contractual matters, and it's axiomatic that if you're going to sue for violation of a contract, you need to attach the contract you're alleging was violated. That's not the type of argument we're making here, which is why
Let's just talk about the general distinction between subject matter jurisdiction and case jurisdiction. You agree with me, subject matter jurisdiction gets to a court's power to hear a class of cases. You know, for example, you can't have a county court hear a divorce. That would be a violation of subject matter jurisdiction, correct?
Correct.
Is there anything that would keep a circuit court, provided that the amount in controversy was high enough, from hearing an employment discrimination case?
To be completely candid with the court, I have not researched amounts in controversy. However, my thought.
Let's assume it is.
Yeah, my thought standing here is that it probably is one of those allegations that has to be accepted as true in the pleading because it's a matter for discovery in terms of what the real amount in controversy is. But
let me ask it a different way. Can you
Sure.
waive subject matter jurisdiction?
I don't think you can, Your
Yeah,
Honor.
you absolutely can. Can you raise it at any time,
Yes,
including on appeal for the first time, correct?
correct.
Can you waive exhaustion of administrative remedies? For example, if your employer said, you know, I know she didn't exhaust it, but we really like her. We don't want you to raise that particular defense. Would you have to take their direction?
That's an ethical question, Your Honor. But I think the answer is probably no, because under the Florida Civil Rights Act, this is an administrative condition precedent.
Okay, so let's say that you don't raise it. Let's say you answer and you don't raise it as an affirmative defense. You don't move forward on summary judgment. Can you raise it for the first time at trial?
Yes,
Can you raise it for the first time on appeal?
if there's not an argument that it was waived by not raising it at the trial court
Well, assume it
level.
was waived. Would you raise it for the first time on appeal?
I suppose you could. I don't think you can ever waive subject matter jurisdiction.
I mean, if it were subject matter jurisdiction, those are all the correct answers. I'm just not sure how you couldn't try an employment discrimination case without exhaustion of remedies if you never contest it. And that's my concern, which is that there's nothing keeping a trial court from hearing a class of cases having to do with employment discrimination. We're talking about case-specific attacks. And if you never raise it, how is anybody to know? So in that sense, I worry that you have a case jurisdiction question, which then means that you can't go outside the four corners. You could easily raise it on summary judgment, for example, but I don't know that you could raise it on a motion to dismiss if it doesn't truly implicate subject matter jurisdiction. And that's what I'm getting at.
Well, to answer your question, I'd like to go to a question you asked the appellant regarding, I believe it was subsection 3 of 760.11. I believe that's actually answered in part by a different section of that statute. It's 760.06, which defines the powers that the FCHR has. Those powers are limited to investigations of Florida Civil Rights Act claims. The FCHR does not have jurisdiction under that section of the statute to investigate federal claims, for example, Title VII. And I'd like to give a very quick example to hopefully explain my point. I have a case currently where in the charge of discrimination, there were claims of Americans with Disabilities Act, which is federal law, also Florida Civil Rights Act claims. We received responses from both the Florida Commission on Human Relations as well as the EEOC. The Florida Commission on Human Relations addressed that which they had jurisdiction of, which is the FCRA allegations. The EEOC addressed that which they have jurisdiction of, which is the Title VII claims. So to address your question, based on 760.06, I don't believe the FCHR even investigates a claim of Title VII because they don't have jurisdiction to do so, which I believe is why the FCRA requires that FCRA claims be identified within the complaint, within the charge of discrimination. That way, the appropriate administrative agencies have the opportunity to address the claims over which they have jurisdiction.
Getting back to the subject matter jurisdiction for 1 second, would you agree that generally a condition precedent is not something that triggers a subject matter jurisdiction analysis? I mean,
I guess it would depend on the context. For example, medical malpractice has a pre-suit notice requirement, and courts have dismissed cases for failure to comply with that.
Yeah, but not for subject matter jurisdiction reasons, for case jurisdiction reasons. One more question from my end of things on subject matter jurisdiction. You agree with me that the federal courts uniformly treat it as case jurisdiction. They're basically saying that they analogize, and I'm talking about Zipes' U.S. Supreme Court case, Myers' 11th Circuit Court case. They talk about it in the context of it being something that's part of a denial or an affirmative defense. So you attack it in the summary judgment context, or if it's readily apparent on the face of the pleadings, like a statute of limitation, you can attack it on motion to dismiss stage. But it looks like the federal courts don't view it as a subject matter jurisdiction issue. Would you agree with that?
Not necessarily, because, for example, if a complainant files a suit after 90 days in federal court, but the EEOC right to sue gives a complainant 90 days to file a suit. Federal courts, in my experience, will dismiss claims that are filed after that expiration of the 90 days, which requires the federal courts to go beyond the four corners of the complaint, because otherwise, how would they know that it was filed after the 90 days? So, to be completely honest with the court, I think it's a very confusing statutory scheme, and we're trying to reconcile Florida state law versus federal law versus Florida state agencies versus federal agencies, and how all these courts and agencies reconcile these two different bodies of law together. But I think that goes to our ultimate argument, which is that we need to keep them separate, which is if it's a FCRA claim, state an FCRA claim, that way the appropriate statutory scheme and administrative remedy can be followed. And then same thing for federal claims. And I don't know if I addressed your Honor's question. Did I?
I don't know. I agree with you that it's not the most straightforward thing in the world. I just keep coming back to the notion that it's not as if, when I think about the difference between subject matter jurisdiction and I think about case jurisdiction, I think about one being a court's inability to hear an entire class of cases versus a court's inability to hear certain cases in a class. And if I'm looking at it in that particular way, your case causes me concern because I don't view the trial court as being forbidden from hearing these particular class of cases. Just because somebody failed to exhaust their administrative remedies, if you don't raise it, the court can't bring that up on its own. I don't see the court having the affirmative obligation as it would in subject matter jurisdiction cases to ask, did you exhaust administrative remedies or did you not? Which seems to be the argument that you would have to be adhering towards. That at trial, hey, just before we get started, let me see, is the amount in controversy satisfied? Is this an eviction case and you're in circuit court? No. Did you exhaust your administrative remedies? I don't understand how it's the trial court's business at that point.
Well, it typically is addressed in complaints based on.
What if it's not though?
I think that would be the subject of a motion to dismiss because.
But yeah, you're missing me because
Okay.
with subject matter jurisdiction, just like any jurisdiction, like a court has an affirmative obligation to raise it on its own because you wouldn't want a court hearing a case that it didn't have the power to hear. So when, like, for example, we as an appellate tribunal, we ask ourselves, what's the jurisdictional basis that you're in front of us on? And if it's not there, then you're dismissed. So the trial court would say, oh, hey, you filed an eviction complaint for $10,000 in circuit court. Somehow it got all the way to trial. Wait, what are we doing here? I'm dismissing this on my own. For it to be subject matter jurisdiction, a trial court would have to make that independent, matter of first instance argument. And I really struggle with the notion that every circuit court judge in an employment case where exhaustion isn't an issue at the beginning of trial has to say, hey, before we get started, did you exhaust? And if the answer is no, I toss you. Does that make sense? That's where I'm really struggling with this.
Sure, it does make sense. First, there is a line of Florida case law cited in our brief that does stand for the proposition that administrative remedies do divest the court of subject matter of jurisdiction. Pushkin is one of those cases. The Seminole Tribe case is another one, but also
Where does subject matter jurisdiction come from?
the court's ability to.
Florida Constitution.
Yes,
Florida
Your Honor.
Constitution. There's a statute that says circuit courts have jurisdiction over this class of cases. Right? You would agree that just generally on a motion to dismiss, you should stick to the four corners of the complaint. General.
Yes, when the exceptions don't apply.
Now, one of the exceptions is subject matter jurisdiction.
Yes, Your Honor.
So I think what Judge Traber's point is, can you, and I know you're pointing to some cases, my question would generally be, I think you think those cases are right. Are they right? Are they right? Are we, if the condition precedent or the administrative remedy exhaustion is an issue of subject matter jurisdiction, we can go outside the four corners, right? But if it's not, you can't. Would you agree with that general proposition?
Yes, Your Honor.
Okay. So in your case, are those cases correct? I mean, is the fact that an administrative remedy is not exhausted an issue that would divest a court from hearing a complete class of cases?
We submit that it is, and I think that's also implicit in the Bellany and Ramos decisions, which are in conflict with each other, but neither of those courts addressed the subject matter jurisdiction issue. They accepted that the trial court was permitted to go beyond the four corners.
Yeah, I want to just follow up on something that my colleague just asked, because when we talk about where subject matter jurisdiction comes from, he's absolutely right. It comes from the Florida Constitution, and you're not aware of anything in the Constitution that suggests that circuit courts can't hear cases, employment cases in which administrative remedies aren't exhausted.
I think the Bellany case does stand for that proposition.
Well, that's a case.
In the
So if we're talking about in the Florida
Oh.
Constitution, is there any constitutional language that you're aware of that keeps circuit courts from hearing employment cases where administrative remedies aren't exhausted?
Not off the top of my head, Your Honor.
Yeah, it's not there. And then is there any statute? Because that could be another jurisdiction granting sort of situation. You know, there's a statute that says that cases in which injunctive relief is demanded is entirely the province of circuit courts. You know, that doesn't come from the Constitution. Is there a statute that you're familiar with that says that this is a jurisdictional issue?
Other than the Florida Civil Rights Act, no.
Okay, where in the Florida Civil Rights Act do you see that jurisdiction doesn't attach if administrative remedies aren't exhausted?
Well, to be fair, it doesn't use the word jurisdiction, Your Honor. It just says it's a condition precedent to filing suit. It has to be, the administrative procedure has to be followed.
But didn't the complaint here allege that all the conditions precedent were met?
That's true, Your Honor. However, there's also case law that says where the allegations and the pleadings are belied by these other documents, they have to be considered.
How far is a trial judge supposed to go? What other documents? What is the standard they're supposed to apply?
Your Honor, to be candid, I don't think that's addressed in any of the cases we cited, other than to say that it is permissible to review the charge of discrimination in this context. They don't address how far beyond the charge of discrimination, and to my knowledge, nothing other than the charge of discrimination was considered.
Where would the limit be then? Kind of piggybacking on Judge Stargel, could they consider any document that's brought into court? Could you then take testimony? Could you take evidence? Does it become an evidentiary hearing? Where's the limit then to your position?
Well,
So they can go outside the four corners. How far outside the four corners?
Well, if we accept the premise under the Florida case law that we cited that administrative remedies and the failure to exhaust them does divest the court of subject matter jurisdiction, then I believe the answer would be documents that reflect whether the administrative remedies were indeed exhausted.
Yeah, and you're doing exactly what I would do if I were in your position, because you've got a couple of DCA cases that say exactly what you need them to say. I think, being a court that's unbound by sister court decisions, I think we're testing that first premise that you talked about, the notion that, and like I said, it's fine if you're arguing in front of a trial court, and this worked for you resoundingly below once Bellany got issued because it controlled the trial court. So in this particular situation, we're not controlled by Bellany, we're not controlled by Ramos. We're just asking about subject matter jurisdiction as a matter of first principles. So without relying on sister court case law and sister court precedent, what's the best argument that you can make as to why there is no subject matter jurisdiction here?
The compliance with these administrative remedies provides the subject matter jurisdiction. Likewise, the failure to comply with it stymie or divests the trial court of subject matter jurisdiction. But as a practical matter, I think it's a matter of getting cases where they're supposed to be. If the claim is a federal claim, assert federal law violations and go to federal court. If the claim is a state claim, assert state law violations and go to state court.
And that could be a winning argument on summary judgment, or, the Supreme Court, whenever it tells us what it's going to decide, will tell us who wins in that particular situation. But that's very different from cabin by the four corners argument, or not, is it? I mean, that's correct, isn't it? So what you're talking about is getting in at the right place. That could be a summary judgment argument. It might be a prevailing summary judgment argument for you. But if we're just stuck at if we're stuck at the four corners of the complaint, that doesn't help you with that, does it?
Well, I think I'm still relying on the DCA cases that you reference you're not bounded by, which say that administrative remedies do divest the court of subject matter jurisdiction. I don't think I have authority other than those DCA cases to offer the court.
To be successful in that, and you're correct, there's DCA cases that say what you're saying, so I'm not taking away from that. Wouldn't it have to be that by exhausting administrative remedies, all of a sudden it magically becomes an employment case? Because the circuit court has jurisdiction to hear any employment case, right? Would you agree with that?
Well,
circuit trial court, state circuit court, any employment case brought under or statute 760.11.
Sure, and that's the clarification I was going to ask for. There's other employment cases that are not discrimination cases that don't have this statutory requirement.
And so if the court has jurisdiction to hear that class of cases, wouldn't, in order to be successful, there has to be something that magically happens to exhaust administrative remedies that makes it that type of case that can be heard? Meaning the case is not a case until all administrative remedies are exhausted.
I'm not sure I understand your question, Judge.
So let me back up. So I think we agree that a circuit court has jurisdiction to hear this class of cases. Would you agree with that?
Yes, Your Honor.
Okay. So in order for you to be successful and there's not subject matter jurisdiction, then they don't become that class of case until the administrative remedies are exhausted. Is that what your position is?
Yes, I think it's fair to say it's not a class of case the court has jurisdiction over until the administrative remedies are complied with.
Okay. Is there any support in statute or case law for that particular idea?
Well, I think it's cases we already cited, Bellany being one of them. I know the court's familiar with Bellany, so I don't want to hash it out, but Bellany, I think, supports that, and also the plain language of the Florida Civil Rights Act, which requires this administrative process prior to filing suit.
I think you've answered those questions as best you can. Is there anything else you'd like to address in your remaining time?
In my minute and 10 seconds, I think I've pretty much addressed everything. I would just say that at the heart of this whole issue, at least as we see it, is a question of whether asserting a federal law satisfies the requirement to assert a violation of Florida state law. And to my knowledge, there's no context in which federal laws are treated as interchangeable with Florida state laws. And to rule that there's no requirement that you specifically articulate Florida Civil Rights Act violations and that Title VII is sufficient, I think would hold that federal law is interchangeable with the state law. But also the whole purpose of the Florida Civil Rights Act is to provide the Florida Commission on Human Relations and also the employers with the right to resolve these cases at an administrative level. And I'll just very briefly say I understand the argument that this could prejudice pro se plaintiffs who don't understand the statutory scheme, but also consider that this could prejudice employers as well, because when they're evaluating what to do with the case and whether to make a business decision, they're looking at what venue they're going to be in. So state court versus federal court are two different venues. They're also looking at administrative remedies. With the Florida Civil Rights Act, an employer knows that if a case is not meritorious, that case will not go to the trial court because they don't get a right to sue in that circumstance. They have the ability to appeal it to a Department of Administrative Hearings, but not a right to go sue. And that's crucial to an employer's analysis in determining how to deal with these cases at that level. So for those reasons, Your Honor, I appreciate your time. I'd ask that you affirm the trial court's order.
Thank you.
In the few minutes that I have left, I just wanted to address some of the issues that, now, I've litigated these cases for probably 2 decades now. There are cases where employers waive the exhaustion. I've had cases where, let's say, for example, I have my Title VII claim or I have a claim, and then a retaliation issue comes up while the employee is still working for the employer. I can turn to the employer and say, do you want me to go through this whole process, or do you just want to tag on this extra claim? And I've had cases where that has happened. I've had cases where the employers agreed to toll the periods for filing charges of discrimination, for filing suit because certain issues come up. So there's a concept of tolling as well. So these cases, regardless of whether you exhaust or not, and I agree with the court that the trial courts do not have the time or they're not obligated to go and scurry through every single complaint to determine if every single issue has been addressed in terms of exhaustion and whether or not. So even if you have the issue of exhaustion, then we have to address the issue of waiver. And those are issues, if you want to raise those issues, my concern with some of the arguments I'm hearing here today is that we're trying to, the employer is trying to convert the dismissal stage into a summary judgment stage. The summary judgment rule is a powerful rule, but the summary judgment case stage requires evidence. And to be able to, and if the city's argument is the prevailing argument, then we're going to turn the dismissal process into a summary judgment process by allowing employers to bring in at the dismissal stage evidence that is more appropriately addressed at the summary judgment stage.
But doesn't that add efficiency to the system? If they can do it earlier, do it cheaper, why not let them do it?
Well, because we have to worry about our rights. Typically, you have to respond to the complaint within like 20 days. If evidence is being brought in, we need to have discovery, which is why the summary judgment process is a little different. I want to have discovery on it. If there are factual issues, for example, like the issue that came up in this case where a version of the charge is presented, that's not the true version. that's a concern, and we need to be able to have evidentiary hearing and issues and that type of stuff if there are certain other factors that the court needs to consider. So my concern is to please don't allow that to be addressed at the dismissal stage without the benefit of discovery. And I agree that if you know how long it takes to get a hearing, a special set hearing on a summary judgment issue in trial court, it's going to
I sit on a trial court. I'm very well aware.
but you months upon months just to get a summary judgment hearing. We need to leave the system in place the way the system is, allow employers to challenge the face of the complaint at that stage. If they want to raise the exhaustion, like most employers do, assert it as an affirmative defense. Then we can do discovery on it, assert it at your summary judgment stage, and then we can go at that point. Now, I think I have like 1 minute and 30 seconds left. And I wanted to address the issue of the FCHR. There have been cases where when the Florida Commission on Human Relations does investigation, there are some cases that we file, the Florida Commission on Human Relations get the case. And they would investigate these cases if the Title VII claimants along with it, they investigate it. When they're finished, they issue whatever they have. They send their stuff to the EEOC, and then the EEOC can choose to adopt it. So I don't think there's any harm here. The system was invented so we don't have two agencies investigating the same thing, the same claims. It's sort of like you have a claim, you have claims under this law, that law. They want the claims to be together because the allegations are basically the same. The remedies may be a little different.
What do you say to counsel's argument, though, that they have the right to know at that early stage where they may end up?
They know. And you know how they know? It's stated on the charge. The charge says, I want it to be filed with both the FCHR, Title VII, and I want you to process this in the state system as well. If you do this claim long enough, you know, I mean, I've done it for 20 years where I know you file your Title VII, you also have the Florida Civil Rights Act claim. Some of the counties have ordinances and you can file it there as well. But everybody who does this stuff knows that that's the way the scheme works. And I urge the court to implement the legislative intent of allowing plaintiffs to have access to this remedy. And thank you for your consideration.
Thank you both for your argument. We'll take the case under advisement.